to impart them knowledge related to certain aspects of intellectual property rights. Today's session is on allied industrial intellectual property rights, and the expert for today's session is Professor Shubha Gokhale. In today's, I welcome you, ma'am, to today's session. And we also have with us Director NCID, Dr. O.P. Sharma. Good morning, Dr. Sharma. In today's session, we will be talking about allied intellectual property rights, about trademarks, its importance in business and startups, and other IPRs such as geographical indications, trade secrets, and industrial designs. All these aspects, till now we have been having sessions which were related to patent, filing of patent, the process of patent filing in India and all. So this is something which queries from the students were coming up, so we thought why not have a session on these aspects related to intellectual property rights. And these things are very much trademarks. They help in identifying the goods and services, or a company that is set up, and even geographical indications. At times we find that there is a confusion related to trademarks and geographical indications, and we hope that lot many queries and doubts will be resolved in today's session, and ma'am will be talking about these in detail. And now talking about the expert for today's session, Professor Shubha Gokhale. She is a professor of physics in School of Sciences, IGNOU. She has a specialization in intellectual property rights, and she has a long research and teaching experience. She has a number of publications, including books, book chapters, research papers in various publications. Ma'am has been long associated with us, and she is interested in uh, topics related to innovations and whatever new initiatives we keep on taking up. And she actively supports us and comes forward to help us with, and she's actively involved in our sessions. I welcome you, ma'am, to today's session. And before we start the session, I would request Dr. O.P. Sharma to please throw some light on today's topic.
Thank you, Dr. Sujata. Good morning, madam, and good morning to all the students who have joined us today in this patent facilitation unit. Uh, In fact, as Dr. Sujata has mentioned, the patent facilitation unit is trying to create awareness about the issues related to IPR, patent, trademark, etc. And over the years, we have seen many of our students are coming up with very innovative ideas, innovative products. They need some sort of guidance, they need some sort of directions also. That's why we have initiated this series of awareness program on IPR related issues. And today's topic is very focused, but focusing on the trademark and other things related. So I think it will be useful to you. I'll not take much time. I just welcome you all and then take advantage of the expertise of Professor Subha Gokhale. And you ask as many questions as you can, whatever is coming to your mind, so that things are clarified, and that will help you in getting our ideas or product patented also. Thank you, Sujata. I think we can initiate our program.
Thank you so much, Dr. Sharma. And I welcome you once again, ma'am, and you may now take it.
Thank you. Thank you, Team NCID, for remembering me and getting me on this innovative, so to say, activity that we are doing for our learners. And surely I am glad that we all are interacting here. So today I had taken a topic which is little away from what the earlier awareness programs or awareness lectures that have been conducted, because I'm sure since it is a patent facilitation unit, I'm sure it was mostly on patents. I expect that little bit of copyright has also been covered in these earlier topics. So we'll not touch on that. But today we'll talk about the intellectual property rights only, but which are our different than patent. Okay. And for that, I have taken this. May I do the presentation? I hope it is visible.
Yes.
Okay. So I have called it allied intellectual property rights. There is nothing as such as allied intellectual property right, but this is just a name for today's topic I had taken. And as this slide is very, I think, familiar to you, we will not waste much time on it, that a concept of property is very dear to any one of us. It is my pen, my mobile, my phone, this and that. Okay. So all that is tangible, is very easy, that, okay, this is mine and this is what is my property, and nobody else can steal it or use it without my consent. This is what we normally expect. Okay. But there are certain topics that come up after the evolution of industrial evolution, so to say, and industrialization and also globalization, that there are certain things that earlier we used to think that mera hai aur kaun le jayega, that thing is now out of bounds, because now we are in a global village, so to say. So anything is available to everybody through internet and through of human mind. It is intangible. It is not like a phone that I'm showing that, okay, ye maine 50,000 rupees leke iPhone liya tha, this is mine. Okay, it is a tangible phone I show. But within that phone, the ideas that were put in, how that was designed, how it was made so that that grip was very nice, that the phone doesn't fall off even if I sweat in my hand. Those are the things that were the innovations that have gone in. They were not covered as a property. You, when you buy the phone, that all that comes to you as a property in tangible form. But there are certain intangible ideas that have gone in. That's where our intellectual property rights come. Okay. And in, like, techno-economic growth, if you want to do of our country and ourselves, we have to be aware about these parts and these properties, and we should harp on them. Okay. And that's why we are looking into the intellectual property per se. And IP is ubiquitous in life. Okay. Articles of food, furniture, clothing, textiles, cosmetics, pharmaceuticals, entertainment gadgets, machinery, books, whatever you think, they are all IP protected, and they are having a lot of intellectual property that has gone in while making them. And the domain of IP is always expanding. Earlier, it used to be only patent and copyright. But now there is geographical indication, as was indicated by Dr. Sujata also. There are also even integrated circuit topography is something that is, a new thing. Nobody even think of that it should be also protected as an IPR. But yes, that is. There is a debate about whether you should have even protection of a traditional knowledge or biodiversity. Those are the things that can also come under the ambit of IPR in coming days, but not now. Okay. So basically, the 7 instruments of intellectual property that are envisaged in the TRIPS agreement are patents, as you are all aware, trade names, service marks, geographical indications, industrial designs, layout designs of integrated circuits, trade secrets. These all 6 are basically called the industrial property rights. They are mostly related to the industry. And there is 7th type of intellectual property, which is completely creation of mind, is the copyright and related rights. We'll not touch into the first and the last today, but we'll cover the ones that are highlighted in this particular square here. And we start with, say, trademark. This is very familiar to you. The moment you say any of this, you can correlate it with a product or a kind of, item that I'm talking about. First logo you are seeing IGNOU logo. Okay, wherever you see there's IGNOU intertwined, you know it is the IGNOU University. Then you have Nike, you have State Bank of India, you have Titan, you have Suzuki Maruti, then Doordarshan तो इसमें तो लिखा ही है, McDonald's, without even having, just by M you know anywhere you see this yellow M and you know what product they are selling you. That is the, you know, importance of branding. Now you all are in innovation, you all are inventing certain products or giving certain services, like, you know, maybe some software that you are developing which will be helpful in like, you know, do some accounting or whatever. You may be having your own great ideas about that. How are you going to use them? Unless you can market it and sell it to somebody else, they are of no use. Just for your own purpose, it is no good idea to build a very nice refrigerator which can work on less than, you know, 100 watts of power, and it is giving me, say, minus 100 degrees Celsius temperature throughout the summer and winter, but I just make one piece of it and I don't sell it. Then it's no use. If I want to really make use of my talent, I have to market that. Now, if I am having a fridge as my product, I cannot just say, because there are, how would I go and tell, say, on a television, buy my fridge? No, that's not the way. I'll have to call it by some name. Okay. Say, whatever, super cool pack or Shubha's invention or whatever. That should be a product which you will identify by a name and which will be your unique name. It is distinct. It can be name, it can be symbol, it can be sign. It will be basically helping the consumer to distinguish your fridge from somebody else's fridge. Okay, somebody knows as Whirlpool company fridge, Godrej company fridge. Then where is the Shubha Gokhale's fridge coming in? Unless I have my name on it in any which way. So it should be some distinct kind of mark that you will have to always give to your product. Unless you give that, it is very difficult for you to even advertise it. Forget about whether it is in newspaper advertisement, television, film advertisement, or even social media. You cannot just say buy my fridge. You have to give a name to that, buy this fridge, and then you will say, okay, this is better than that fridge, this is comparable to that. You can give comparisons also, how it is better than Alwyn, how it is better than Godrej, so on and so forth. But that time also, when you are comparing, you are giving names to this Godrej or Tata or whatever, basically through your trademark. And this trademark has to be registered. Why it is to be registered now? For example, you have a small business, you think that, okay, I'm not going to produce more than, say, like, okay, I say I say make good cakes. Okay, I bake cakes, and in my vicinity people come give me order, I bake the cake and give it to them. They all say, okay, by Shubha's cakes. That is what my locality knows it by name. Now, when mouth publicity happens and people start talking about it, I start getting more and more orders. I do try to give it and complete their orders also. But there is some other wise man next door who just sees that, okay, I'm getting a very nice name, Shubha's Cakes, and they are very good and there is a market. He just goes on the main road, he opens one shop, calls it Shubha's Cakes. I have nothing to do with it. He sells some inferior products under Shubha's Cakes name. Now that is going to affect my credibility, because everybody is saying कि मैं तो उस शॉप में गया था, Shubha's Cakes में गए थे, cakes तो बिल्कुल अच्छे नहीं थे, don't go and buy, I lose business. That's very reason, because I did not go and register Shubha's Cakes as a trademark or trade name. If that had happened, I could have sued and put an injunction on my neighbor from starting that shop. This is where the importance of registration of your trade name and trademark comes in. Okay. Now, trade names, you know, Godrej, Tata, TTK, they have all these are company names. These are trade names, okay? But under Tata, you have various things. Tata's aviation is, say, for example, maybe Air India or Vistara. TTK, there are so many products. When they make it pressure cooker, it will be called Prestige. So Prestige is also a trademark. Okay. TTK, Godrej, Tata, these are business houses. They will be having their trade names. Under that, they will have various branches for different products. They will have different brand names also. Okay. So those will be again trademark. And they should be registered trademark. This is the only legal way you can stop anybody else using that same name. Now, one thing sure, it is legally not like linked to quality. Okay, means if you give certain name like okay Shubha's cakes, then it is not like patent. In patent, you say that okay, this much amount of acid I'm putting, this much amount of base I'm putting, this much of salt I'm putting in, and this much of to make a particular molecule, and this molecule is used for say curing headache. So that is the way in patent it is happening. Here it is legally not binding on me to make good quality cakes, but it is for my own credibility. I will have to build my brand by my quality. When you buy something, you go in market, you say there is something, some salt is there from X company, there is some salt coming from Tata. I'll say, okay, you know that name. It must be good quality. The brand has been built by them, by the association of the quality. It is in the mind of the consumer. The quality is expected of them. So that all thing is related with this name. Okay, Godrej, Tata, TTK, whatever names, Intel, HP, iPhone. So all those things, you have certain kind of quality that is in your mind when you think of that name. Just mobile phone will not give you any idea about that. When I say it's Samsung, it adds something to it. When I say iPhone, it adds something to it. This is what you're basically trademark. And let me tell you, there are many companies which are having their entire business only in their branding, the value, the brand value, so to say. Okay. For example, take example of your say Swiggy, Zomato. They don't have a single asset to show to them. Neither there is any factory in their name, neither is there any corporate house in their name, neither is there any big office space in their name, neither are even the scooters or bikes that they are delivering are in their name. Nothing is in their name. But when you say Swiggy, yes, it clings me, okay, let me buy from them. They will ensure me a service that I'm expecting from them. Okay, so this is where the brand value comes. Brand value always even helps you in while you are trying to raise some funding. In if you go and list your company in a share market, then that people will go and buy your shares just by that name, right? They are not going to ask go by just by the name fridge. They will go by your fridge, your product, your company. So these are the importance of trade names and trading trademarks and their registration. And I think it is very imperative on all of you who are developing any product. You may patent it. I have no quarrel about it. But you should also have your brand with which you can do your advertising of that particular thing. There are various types of marks. Well-known trademarks are there. Well-known trademarks are something, one that, okay, as you are know that by now that all these intellectual property rights are territorial rights. You have to go and register in all those offices only country-wise, then they get protection, right? So somebody like, there is a trademark like Coca-Cola. It is so well known that had they not even registered it in India, I cannot bring any cold drink by name Coca-Cola from my company. It is a well-known trademark. There are certain well-known trademarks. Many are there like that. Even in India also, we have so many like that. Amul is, for example, one. Godrej is one. They are well-known. Then there are other types of mark. Is the collective marks. Is the means like it is not a single company, but agglomeration of or partnership. They are not in legal partnership, but they are proprietors who come in association, and then they can use it collectively as a mark, like WWF, Worldwide Fund for Nature. These are type of collective marks. They are all not proprietors of anything, but they use WWF under certain legal bindings on them, obviously. Then there are certification marks. They do not like indicate the origin of goods, but certify the quality. Okay, like we have in India ISI mark for like electrical goods or whatever. They should comply with certain quality. Only then they can be marketed. There are even prestige or any pressure cooker. There are ISI mark pressure cooker. We always go and ask for, okay, yes, which ISI wala hai na, means that kind of certification is there, means they are good. Ag mark for food products is there. Hallmark for jewelry is there. So those are the things that ensure that the customer gets a good quality. But this certification mark has nothing to do whether it is coming from Tata or whether it is coming from Godrej or whether it is coming from Shubha's Cakes. It is just a certification mark that okay, it is complying with these qualities. Okay, but this is little different than the geographical indication, as I'll just show you in a while, because indication of origin is not in this particular case. It's only the certification. Okay, it's like I can product. It's like my product. This fridge I am like cool pack fridge is ISMR. That is the additional. Nowadays even we have energy. BS this one also energy efficiency mark is also mandatory on electrical goods. So those are the certification marks. Then form of trademark can be visual. Okay, you can see the words. In the initial slide only I show you that you see that one full blue circle with a slit in it, and it is State Bank of India. You know it. You can associate it with a visual. It can be 2-dimensional, 3-dimensional, or it can be even combination of like a shape as well as words, like Doordarshan written in that logo. So it can be a combination of things. Or S was written in Maruti's Suzuki cars. Then you can have 3D shapes of the goods also. The good at the shape of the product itself, like Coca-Cola bottle, the shape of the bottle itself is there, like one of the trademarks. Nobody else can copy the same shape of that Coca-Cola bottle. Or packaging, how it comes, like it always comes in blue striped pink paper or whatever. Those are also can be trademarks. Then there can be some kind of audio marks. Audio marks, let us see whether you can see the here this example. I can show you. You will hear something, and definitely immediately you can make out what I am talking about. Right? iPhone. You don't have to think twice. You hear it and you know. Intel inside. You know this. A short note. Very short note. T-Mobile. Nokia, without saying. Okay, so immediately you know that it's some movie from 20th Century Fox is coming up, right? So these are the kind of audio marks. These are all registered trademarks by these companies. Okay. Now another one I have written here is olfactory mark or smells. Now that is very difficult. How can you describe that? Musical notes, okay, you can give the notation of that musical note and go and register it. Smells, it is very difficult. No, just like jasmine smell with this and that. It's pretty difficult to even register those kind of. So they are very less in number. Second factor about the olfactory smell marks is that any trademark for that matter, you cannot have a trademark which is you cannot have a trademark which is a functional part of that product. For example, like you cannot uh, like register a perfume, means a smell of a perfume for a perfume product, because it is that product itself. You cannot have. So some there are some weird kind of olfactory trademarks have come, like some shoe company has its shop which has got always a kind of fruit, some particular fruit smell. When you enter that shop, it is a fruit smell that comes in. So that kind of olfactory mark is registered in the name of a shoe company, which has nothing to do with those fruits per se. So those are little difficult kind of trademarks. But my suggestion for you would be that you go in for the visual marks or words that will be very easy for you to go and register. Only criteria, it should be distinctive. You can have like some different name. You can invent a name, or you can have acquired. You can have your surname also as one of the names. But it should be uh, distinct. Basically, that is the main thing, and it should be non-deceptive. It should avoid misleading. Earlier next to a McDonald's, somebody had started a company called again a burger shop called McDonald's with half M cut, looking like N. But that is a misleading. It is non-deceptive. It is very deceptive. So it will definitely will not be registrable. It should not be contrary to public order morality. This is very standard. You cannot even register any state emblems. Okay, flag of a country, or you cannot go and register those. And secondly, you have to register your mark for specified classes of goods and services. Like, for example, if you go and there are different classes, automobiles may be there, electrical products will be there, food products will be there, even services, software companies, banks. These are all the classes. So I can register my mark for all these classes, or whatever I'm having business in, all those classes I can do. So basically, you have to go and make sure that you register in all those classes. Otherwise, you cannot stop somebody. It's like, say, you are making a fridge and you register it like, X fridge as your name. But then if you don't go and like, protect it against with this under the other class, then somebody else can take the same name for, say, a burger shop. That cannot be stopped. So across the classes, if you are having services, you should go and register in under all those classes. You have to pay obviously the fees separately. In India, you can do electronic online filing of trademark nowadays. You don't have to bother much. It is a very lucid process that is there, and you can go ahead and file your forms. If need be, you are having your patent attorney, you can take help of them. But otherwise, it is not very rigid or difficult. Then second part about important part about trademark is that right to use the trademark in relation to goods and services are protected here. Okay, but as I told you, the state emblems or hallmarks are not intergovernmental organization emblem. You cannot use, like, you cannot use UNO. You cannot have your company under UNO, for example. You cannot use those trademarks. But there is one thing that I would like to tell you here is that trademark is something that is timeless. What I mean is that your patent comes in and it is protected for, say, 20 years. Beyond 20 years, it comes in public domain. You are aware of that, right? But if you are having a trademark, then its time, at the time of registration, its validity is for 10 years. But every 10 years, you can go on paying the fee and keep it continuing, and you can keep it continuing it for eternity. It is not time bound. Your trademark can run, like, there are like some Swiss Swiss watches. There are certain marks which are in there, like, more than 100 years there in public. It's like they are their trademarks. they have been able to keep that under their registration because they have been paying it and you can renew it. Patent is not so. Every 20 years it will come in public domain, you lose the, any right on it. Moral right, of course, it is yours, but otherwise you lose the financial right, so to say. So that way, trademarks are more stringent or more effective. You can come up after certain more years, you can come up with better product also, and under your same trademark you can use it, or under your same trade name you can market it with some other brand name also. So those are the things that are different than what you are having in your patents. This you should remember. Then, as I was telling, these are geographical indications. This is something a very typical thing, and you are seeing certain things here, like a Darjeeling tea is there. Then there is a weaving style of Paithani weaving sari is there. Alfonso mango is there. Then there camembert cheese is there, or champagne, some sparkling drink is there. These are the products which are protected because they have got their peculiar properties due to their geographical origin. And it is the best method to indicate, to show the geographical origin of the goods and services. This is like different than what I was talking about, the collective marks in the trademark. Okay, there that or certification marks rather. Certification marks, you are not able to give the origin there. There you are just saying that complying with this particular property. But now here you can always say that this is Darjeeling tea, or this is basmati rice, or this is a particular cheese that is coming from that particular Haryana area, or these are the wines and spirits which are made from the grapes grown in Nasik area of Maharashtra. So these are the special quality of that product because coming out of that particular place, the kind of it can be basically because of the natural resources available there, the kind of land it is there, kind of water they are having, kind of season they are having, temperature conditions, climatic. Also, there are people who are trained in the art of producing. Say, if somebody is making a champagne or cheese, then how that is made is a skill. And making that particular product, you by that region people only gives certain, taste to that product, then obviously it should be protected. Like Paithani is an area where the weavers are trained to weave in that, from their traditional knowledge it is actually. So now nobody else can sit in Delhi and say that, okay, I prepare my Paithani saris. You cannot. It is geographical indication is given to them. I cannot use as my woven sari sitting in Delhi a name Paithani. Right? Same way, it can be region wise. Means like, there is a registration of GI in the patent office itself. It is under the IP office nowadays, and almost like 500 GIs are already registered there, and you cannot use that name unless that product is coming from that particular area, or you are making those things in that particular area. And secondly, most of like you may have a particular name coming from that part of that, this like Darjeeling, it is coming, the Darjeeling tea is produced in Darjeeling, a geographical indication name is there. But for example, Alfonso is, there is no region written there, but it is attributed to a particular region of Maharashtra that mango is coming from. So the name, that geographical indication may or may not have the name of the region included, the locality included in its name, but the originality is given in the register that you have to check. Okay. And under protection is that GI is not owned by a single owner, as I told you. It is a collective. The farmers in, say, area near Haryana region come together and can say that they can put their product under the name, say, basmati rice. So any producer in that region can use that GI on the product, provided the preparation, it is prepared by the norms that are set out when we are filing that GI while registering it in the national register. And it is similar to the certification mark, as I told you, but it is identifying the origin of the good there. And government can register these GIs in the international register also. All our GIs are also registered in the WIPO registers for worldwide protection also you can get for that. Again, putting a false GI is an offense. Then another thing that is coming up, and this is area that I would like to talk to you, because you are in patents, you are already doing certain products which are patentable, but there are certain parts which come to, you can, give a shape or give a, a particular shape to that particular product, or a texture to that particular product, which may not be patentable. It is not such an innovative idea with technological use and inventive step and all that, but something that you have incorporated which gives that particular product a look that it is showing, and it is again distinct. So you can have those as design patent, as they call it, or industrial design. It is the ornamental or aesthetic aspect of the article, okay, visual appeal, and it can differentiate a product by a three-dimensional features of a shape, or a surface of a perfume bottle, or a 2D pattern on the lines and shapes or colors on the bed sheet, or some curtains that you use. So those are the things that are not patentable, but still they there is your uh, so to say ideas and intellect has gone in designing that. So this industrial design protection is given to you. It should be, of course, new and original. And second important thing, it should be capable of mass production. Okay, it can application, or an application on an article of a utility. It should be available and possible to be used and produced in mass production. Mass production is also a patented condition of patentability also, naturally. And secondly, the shape should not be determined merely by the functionality of a good. Like tomorrow, if you are saying that a rolling ball is made and it is of a spherical shape, obviously it has to be a spherical shape. There is nothing new or original in that. So its functionality itself is going to be determined by that. Then it is not going to be a design, industrial design for you. But industrial design has to be the integral part of the product. Whereas here I'm comparing it with a trademark. Trademark is applied on a product. Like, you are writing, say, Hawkins or Prestige, or sticking something on your pressure cooker. But it is not integral part of my product. It is a mark that I'm putting on top. And industrial design should be original, new, but it need not be distinctive. Whereas your trademark has to be distinctive, because otherwise it will lose its identity. Okay. And if we compare industrial design, copyright and patent, then if the article is not mass produced, or a design cannot be applied for a useful article, then that it will be a work of aesthetics. If it is one time doing kind of thing, then it is only copyrightable. It is not protected under industrial rights, so to say. And sometimes your industrial design may be sufficiently innovative to be protectable as patent. Say, for example, if you are making some handle grip of like a mug or a jug, and there you are taking care of, say, for a person who was having 6 fingers, that kind of innovation, if you are done in that handle of a jug, then in that case that will be protectable even as patent. You will have to, of course, subject it to the test of patentability, but you can get as more stronger protection, obviously, than industrial design. And industrial design protects the commercial exploitation of design idea through the product articles that embody it or reproduce. And many of the court cases nowadays are coming in the fashion design world, because somebody is claiming that my design idea was copied and was put in on by some XYZ model on this show. So those are the industrial design protected products. And just in short, now we'll take about integrated circuit layout design. It is a very high end, so to say, protection, and it is not applicable, so to say, in any particular tangible, so to say, or practical use that we are in the field of. But it is one of the IP instruments, because lot of effort goes in making a small chip of integrated circuit. When it is made with, like, intelligent design, with smallest possible shape, maximum number of articles are put in there, and so on and so forth. Once it is made, then it is mass product, and that is going across, like, go in Singapore and get thousands of ICs and bring them to India. It was very commonly it happens. So their protection of that integrated circuit is given just because a lot of money has gone in basically designing it. And after designing it, once it goes into production, it is very, very possible to reverse engineer it and to stop copying it or reverse engineering it. This kind of protection is provided, but it is limited to only big companies who are making the, it's a special protection given to companies who are calling shots in the IC industry. And it is basically act against reproducing any layout design fully or in parts, and importing, selling, and distributing the commercially protected layout design or IC, incorporating it. But the design created independently by third party is not prohibited. Okay, in your lab, if you make such same IC, then it is not protected or prohibited by that protection. And last, not the least, is the trade secret. It is the best kept secret, is the formula of Coca-Cola. They have neither patented, nothing. They have been able to keep that secret. And this is something that is a very dicey thing, because in patents, when you are disclosing everything, it is in public domain, but in 20 years, you can stop anybody else from using it. Whereas if you are able to keep the invention or information that cannot be protected also under IPR, for example, innovative, this, that, it doesn't fall in the tests, it fails in the tests of set tests for giving the protections, then keep that as a confidential. Trade secret can be invention, idea, survey method, manufacturing process, experimental results, chemical formula, recipe, financial strategy, client database, anything can be kept as a trade secret. And as I told you, it can be when it is not patentable, or when patent comes in public domain in 20 years. But when cost of patent is also prohibited, because you have to go in every country protecting it. And when your product should be difficult to reverse engineer, because if I can buy a product that you have sold it, and if I can make myself by using my own intellect, then you cannot stop me from doing it, and your trade secret is busted. So it should be non-reversible kind of product, then only it should go. And you have to guard it obviously by your own means, by restricting number of people who will have access to the secret information, or having many different people having access to parts only of that, so that when the entire thing comes together, only it makes the product. And signing the confidentiality agreement with the business partners and employees is fine, but that is only a legal recourse, because if it is out of the bag, the cat is out of the bag, then all these confidentiality and all agreements are just a legal thing to punish them, but then your trade secret is blown in any case. Okay. And emerging issues, as I told you, are traditional knowledge or biodiversity, electronic commerce, internet domain names protection, database protection, software protection. These are all the things that are being debated, but we can discuss them some other time. Okay, thank you.
Thank you so much, ma'am. We have a query. Kunal has something to say. Please, Kunal, please come here.
Good morning, ma'am.
Good morning.
Thank you so much, ma'am, for this wonderful session, ma'am. And it was really very informative, ma'am. Ma'am,
Are you driving?
yes, ma'am. No, ma'am,
You should
actually,
not.
I'm not driving right now, ma'am. I'm just
Okay.
inside my car.
Okay.
Ma'am, ma'am, I just want to know, let's say if someone has applied for a patent and the patent has already been granted, and already, ma'am, 11 years has lapsed while just granting the patent. So now I'm having 9 years in my hand, ma'am.
Yeah.
So is there anything, ma'am, that I can renew my patent for next 20 years or so?
Well, You are talking of something called evergreening of patents.
Yes, ma'am.
Okay. Now, this is what a technique used by many pharmaceutical companies, so to say,
Yes, ma'am.
very, very commonly used, because they have put a lot of money in, preparing a particular molecule, medicine, and then they went and protected it. But at the end of, say, 15 years, then they tried to invent a new use, which was not the part of the first patent. Okay, certain thing that, okay,
Uh,
am I audible?
yes, ma'am, you are audible, but
Sorry,
it's
no,
not.
okay. I just changed the device. I lost the internet connection. Okay. We are talking to Kunal. If he's still there.
Yes, ma'am. Yes, ma'am.
Okay. So Kunal, the thing that is mainly many companies do who have a lot of resources is to go and prove that this thing has got another use. Okay, but again, you have to be sure that the same molecule that you had has not already been patented by somebody else for, say, cardiac diseases.
Yes, ma'am.
Okay, that
Yes,
kind of thing. So then you can establish, okay, this is a medicine that I am bringing in for a cardiac sorry, neuro use,
yes, ma'am.
as a new use.
Yes, ma'am.
And
Okay.
then it will be just like, same process. You have to undergo all those drug tests that you do perform for all the, you know do miss process for getting any patent. You have to
Yes.
undergo all that entirety.
Okay,
But
ma'am.
it will be again for, and you have to, because see, the point is that your invention is already in public domain by yourself.
Yes, ma'am. Yes,
So
ma'am.
you have already lost the distinctiveness by
Yes,
your
ma'am.
own patent.
Yes, ma'am.
Okay, so unless you have some additive step in it,
Yes, ma'am.
it's very difficult to get into it.
Okay.
Some kind of new innovation you will have to bring in that,
Yes,
which
ma'am.
will be a augmentation which
Yes,
nobody
ma'am.
else has done. Then it
Yes,
can be treated as a new patent and you can get it. This is called
ma'am.
evergreening of patent. Itself is one of the very debated topic, actually, whether it is in the, means, so to say, even morally correct. Because
Yes,
when you patent something, you were aware that you are going to put it in public domain after 20 years, but you
yes,
chose
ma'am.
to go with it. Now you are rethinking about, no, I want it for 40 years. Then you have to put your own efforts for bringing it into some new form.
Okay.
The same molecule you cannot go and patent again because it is already in public domain by yourself.
Yes, ma'am. Yes, ma'am. Ma'am,
Huh?
ma'am, I just want to know one more thing, ma'am. Ma'am,
Hmm?
is there anything like patent of invention and patent of innovation?
अलग नहीं होता.
Uh,
Patent itself should be, having those three tests:
okay.
innovative, inventive step, novel, inventive step, and industrial application.
Yes, ma'am.
All three have to be there, then only you get a patent.
Ma'am, actually, in some countries, ma'am, they are offering patent of innovation, ma'am. That is why I asked this question, ma'am.
Patent of industry under TRIPS agreement nowadays, everybody is at the same law.
Oh, okay, ma'am.
Okay.
Okay, ma'am.
So I don't know. Maybe US you can try because US have their own petty patent, they call it.
Yes, ma'am.
7-year
Yes, ma'am.
patent. It is a small
Yes,
patent,
ma'am. Yes,
petty
ma'am.
patent.
Yes,
So
ma'am.
there you can, that you can try.
Okay.
But then again, novelty is lost, na?
Yes,
Because
ma'am.
you are
Yes, ma'am.
already holding one
Yes, ma'am.
patent which is in public domain.
Yes,
Huh.
ma'am. Yes, ma'am.
You yourself have destroyed its innovation,
Yes.
novelty.
Yes, ma'am. Yes, ma'am.
Keep
Thank
that
you
in
so much,
mind.
ma'am. Thank you, ma'am.
Welcome. Welcome. Anything else?
Any other query from anybody else? No questions? Ma'am is there. You can ask any questions, means if you have any doubts, queries. Anup, you have any questions? Oh, Kunal has one more question. Yeah, please, Kunal.
Extremely sorry, ma'am. Sorry to disturb you, ma'am. Ma'am, actually now ma'am, I want to know how long does it take to get a patent nowadays, ma'am? Because ma'am, in my case, ma'am, it took almost 9 years, ma'am.
Yeah, but I think now there is a fast patenting process is there, and I think 18 months is what their claim is. So maximum 2 years.
Okay. Okay. Thank you, ma'am. Thank you, ma'am.
Madam.
Hello, ma'am.
Yeah, hello.
Good afternoon. My name is Anup. So I'm at a office environment, so I won't be able to on the camera.
No
But
issue.
yeah, yeah, ma'am. What I see that if I want to select the jurisdiction, like if my patent, if if my device, the one which I'm going to patent, have a specific uses in certain areas of the world, like the US, Germany, and other. So if I take some more time to dig into like which area I need to do this, which area I need to file this. So is the PCT route is the PCT route will be the best fitted for it, or should I first get into the
Actually, PCT route is actually the best because then you can get protection in one go in various different countries. But I think for still for US and I think Japan also you have to go separately. Okay, they are not under PCT. You better check
okay?
the company, the countries that you are looking for, whether they are covered under PCT.
Mm-hmm. Ma'am, is there any
Okay, we can discuss this separately if you like, because on
yes, yes,
WIPO website there is a list of countries which are covered under PCT filing. Only
true,
those
ma'am.
countries you can get a cover under PCT filing.
Okay,
And if you are
true,
not
ma'am.
interested in those countries that are covered under
Yes,
PCT, but only specific say Germany or sorry, only particularly say Japan or US, then better file in USPT or JPO separately.
okay, but there is also a certain, I guess, I have read it. Like there are some requirements, like signed by PCT or the WIPO. So for even filing it, so if the countries are not under the WIPO or like PCT, so again, what are the justification that I need to give to them?
No, there is nothing justification. See, if you have one patent protected in under say Indian Patent
Mhm.
Act, first of all, first
Yeah.
filing you should do in IPO here in Indian Patent Office.
Okay.
Indian
Hmm.
Patent Office also facilitates you PCT filings. Through that
Okay.
you can do PCT filing. Point is that the country that you are looking for, if there is already another same product already
Hmm.
having their own protection, then the novelty condition will be violated there. That's the point.
Okay.
Or
Uh,
the point is that if they have granted the patent after your application is done there, then you will have the priority. It is a
okay.
matter of time game also, no, you know that, no, PCT
Yeah. Like
filing date is very important for all of you, that you should be always looking at, because
um,
the
uh,
first application that you put in, that is your
mhm.
priority date.
True.
you
True.
can
Date of.
you can give your
Mhm.
entire patent details, even filing do after even 6 months, you have that much period is anyway with you.
True. Mhm.
But filing the first
Filing date is
instance
very
that
important. Mhm.
this product for this particular use or whatever your procedure that you want to do has to be there, that basic preliminary form as they call it, that preliminary filing has to be there before anybody else has done.
There's a very minute thing which I need to know, like uh, about the IPR thing. So in the remote areas of India, just from the understanding that many of the people do not know about IPR, how to protect their innovative things. But yes, there are also provisions of like hardbound laboratory copies if they have proven something. So can on that basis a patent be claimed? Can the priority date be claimed? under certain circumstances, not on a proper route, I will say, but again, yes.
Mm, No, I don't know. It's like whether see, the point is that if somebody else has already grabbed the patent before they have done it, then it is only possibility is that that should be contested in the court of law.
Okay, okay,
That they didn't have priority, we had the priority, and that priority you will have to prove by these means that you are saying.
ma'am. I guess we can have another talk sometime if I, because there are some
There
particular
is
identified questions. Yes,
yeah,
and the
this is
workflow.
possible, no problem. But I think
Okay,
in that case, I would suggest you can have somebody from Indian Patent Office coming in. That will be still better for you. They can give
okay,
you
ma'am.
first-hand information more than.
Okay, the
I mean, I can give
preliminary
you
thing.
whatever is
Yes,
theoretically available.
yeah. I would first rather do that, the preliminary part with you, and then I can to the controller, like Unnat Pandit sir is there. He's
Hmm.
right now the controller. So I have been in contact with him for some time. I'll reach out to you, ma'am, once.
Yeah, sure. You can reach. No problem.
Thank you, ma'am. It was a lovely session. Thank you. Sujata ma'am, kindly let
Okay.
me connect
Most
with her
welcome.
later on. Thank you.
Thank you so much,
Thank
ma'am. Any other query from anybody else? It seems there are no more queries, ma'am.
Okay. Thank you. It
Ma'am,
was pleasure.
it was a very informative, very interesting session because we all have been. Yeah, Kunal, do you want to say anything?
No, he's writing something, I think.
Yeah. So, because we have been talking about patents and all, but this was a new chapter for all of us, and such queries, all our innovator students keep on putting across to us because they are worried about branding of their products, their companies, and they are thinking about how to get their trademarks means protected and what they can do about it. So, I think lot many queries have been answered by your talk, and we will be putting the recording of this session also and earlier sessions also on our
Sure.
PFU website. So thank you
Sure.
so much, ma'am, for taking out
Most,
time and being with us. Thanks a
most
lot.
welcome. Most welcome. It was pleasure being with you all. Thank you.
Thank you, ma'am.